Good morning, everybody. Welcome to my first of a 12-part video series on the contracts that we use in our business as realtors and closing agents. I'm very excited to do this. It's going to be every Tuesday and Thursday for the next 6 weeks. And today we're going to start off by talking about how to prepare a NABOR contract. This is a quick how-to. We're not going to get into the nitty-gritty details of every section of the contract. We're going to talk about the blanks and what goes in them. Of course, I am an attorney, so first we start off with the disclaimer that I am providing you advice, but it's not legal advice. And, if you have any specific questions, you can ask them. I will say you can always put your questions in the chat or shout them out as we go through this. A little bit about me. I've been an attorney for over 20 years. I serve on the committees that draft the NABOR and FARBAR contracts, so I know them very, very well. We have a title company that we use, my title company, Paradise Coast Title and Escrow, for closing services. My people know the contract as well and are always available to answer any questions that you might have regarding the contracts. Today, we're going to be in kind of a hurry up mode. I want to keep these short so that you can get your day started. We're going to talk about filling out a NABOR contract for a married couple selling to a trust. I have a few addenda that we're going to attach to the contract, our disclosures, and I'll take your questions whenever you have them. You should just feel free to shout it out whenever you want, or just put it in the chat. So I'm going to switch over. We're going to use Form Simplicity today, which is the um, forms program provided by Florida Realtors. And we're going to screen share again in Form Simplicity. Give me 1 second. All right. Close that. All right, so this is your Form Simplicity. I have loaded a NABOR contract and some addenda into Form Simplicity for ease of use. This is the NABOR Sales Contract Residential Improved Property. This is where we're going to start today, assuming it loads. Assuming it loads. There we go. All right, so NABOR standard contract. You've got your buyer and seller information, your property information, your price information. In NABOR, we try to keep the form, the fillable fields to the first few pages. Now, we're going to be selling my house to a trust today. So first thing we need to know is, who is our seller? Well, to get our seller, because we're selling my house, we're going to go to the Collier County Property Appraiser's website. See here, I've loaded my property card. I searched and looked at the address, and here it all is, 1163 14th Avenue North. It's owned by Samuel J. Saad III and Amy Saad. You have other information like your legal description that you'll need. So let's start right off and dive into this contract. So we're going to put our seller information, Sam J. Saad III. We're going to copy it just as we see it in the property card, because we don't want to guess if there is a junior or a fourth, as there is in my case, running around. So we want to be very careful. Notice I'm putting the address listed on the property card for my seller. Right here is the address of the seller. This is where the tax bill goes. That's the address that I'm going to use on my contract for the notice provisions for the seller. Why is that important? If I ever had to send a legal notice, I've got to do it by mail or email or fax, and the contract only provides an address. So it's very important that you put your notice address for the buyer and seller here at the top of the contract. Now, I said at the beginning, we're going to be selling to a trust. So the way we fill out for a trust, you always have to know who your entity is, if it's an LLC or a trust. In this case, we're doing Bob the buyer, trustee of the Bob Buyer Trust, which doesn't fit. So we're going to shorten this. And we're going to give Bob an address that we know if we have our listing or we have our buyer, because we filled out a buyer broker, remember, where we've already seen the property, we've done all that. So we're just getting ready to make our offer. And Bob also lives in Naples. So this contract, the NABOR contract, has got the property up front, and it's got two sections on lines 9 and 10 here for other parts of the property that you might want to add. It also has a section here in line 14, 15, and 16 for personal property. Now, I'm going to tell you, we're going to sell this property turnkey furnished. That should scare all of you when you hear me say that, because what does turnkey furnished mean? We don't really know what turnkey furnished means. So what we're going to do is put in here, see attached inventory. See how I did that? I didn't write turnkey furnished. I wrote see attached inventory. When you put furnished or see or inventory or turnkey and you don't use an inventory, then you've got a problem defining what the actual property that's going to be sold comes up at the walkthrough, is a fight during the process. So if we put C attached inventory and then we fill out an inventory, which I'm going to show you later, it makes life much easier. We may want to exclude some personal property. So you have two choices. You can either write the exclusions here, which I'm going to exclude my home generator, we'll say, just for fun. Take it with me. And that's an attached built-in home generator. So if we want to exclude it, we have to write it in here. You can exclude other things. If you're using inventory, you have the opportunity to put exclusions right on the inventory sheet, which I will show you. Next up, we need the address of our property, 1163 14th Ave North, Naples, Florida, 34102. And we get that from right here, site location on our property card. Next up, we're going to need the legal description of our property. So we go here, get our legal, we copy it. Notice this is the brief legal. This is not the full all-on legal description of the property. This is just the brief legal from the property appraiser's website. We paste that here on line 23. And we don't forget to put which county we're in, because there may be a lake park in a different county. Now, if I was selling a condominium here on line 26 and 27, I would fill in the parking space information, the garage, cabana, storage locker, or boat dock information. We're selling a single family home, so we're not going to use those. Now, let's just say we need a purchase price. Let's just say we're going to go for $3.5 million. Now, that's our top line number. This is the number that the compensation is based off of. This is the number that the doc stamps is based off of. This is the number that the title insurance is based off of. So very important that we put our purchase price here in the top line. Let's say we're going to make a deposit of 10%. We're going to split it up into two deposits. I'll show you how to do that. We're going to make the deposit due. Say the buyer's got to wire money. They got to wire it in from their bank back north. So we're going to say is due not later than 5 days after the effective date. And then we're going to do an additional deposit due at the end of inspection periods, which I'll show you how to fill that in. But we're going to say we have a 15-day inspection period. So what I like to do is make the deposit due the day after the inspection period. You don't have to do that, but it just makes the buyer feel more comfortable, like they get to complete their inspections. But you're going to see in this contract that that is not going to be super important because deposits and inspections are run separately from each other. Now we're going to get a mortgage on this property. We're going to say they're going to take out a $2 million mortgage. And then this form simplicity in most forms programs auto populates that the balance to close, the $1.15 million, is going to auto populate. If you had seller financing, you would fill it in here on line 37. If you had other money coming into closing, maybe a gift, you could put a gift in here, gift from parents, maybe, and you could put an amount and it would calculate the difference. We're not going to have a gift today. So we've got our purchase price, our deposits, when they're due, our loan proceeds, and this is not a class on financing. I've got a separate class that I'm going to do on the financing provision, but let me just tell you, don't skip line 36. If you've got a mortgage coming, put the amount here on line 36. Okay, next up, we have to decide how long we're going to make our offer on line 44. I like to use 8 o'clock p.m. as my deadline because people have to get off work. People have things they've got to do. We have to have conversations. You can make it sooner if you are trying to push the seller to make a response in a sooner fashion. Today is the 5th, so we're going to give them 1 day to respond. That's pretty fair. NABOR has a counteroffer after 2 days that is revoked. So you have 2 days on any counteroffer. You can change that if you'd like. We're not going to mess with that today. Closing. So I said it's going to be a financed transaction. So we need to have time to get financing done. Let's do a 45 to 47 day close. I think that's going to take us out here to September 18th. Notice I'm not closing on a Monday or a Friday. I'm closing this time. We're going to close on a Thursday this time. Tuesdays, Thursdays, Wednesdays are good. Never on the 15th of the month, never on the 31st or the 30th of the month. The title company is busy and you want to make sure that you get top priority. So spread your closings out Tuesday, Wednesday, Thursday, not on the beginning, middle, or end of the month. Okay, so next up, we're going to fill out our financing contingency. Remember, this is a NABOR contract. On the NABOR contract, the financing contingency just gives the buyer and seller the right to terminate if they don't get the financing in place at the end of the period. So we'll fill out our box for financing. If this was cash, we would have the cash box here, but we're going to finance it. If we were seller financing, then the box is down here on line 81, but we're going to do conventional financing. So we'll check the box on line 60. And it's going to be a conventional mortgage. We have the choice of conventional, VA, FHA, or other. If you were going to use like a USDA or a ship loan or something like that, we're going to do a conventional mortgage on this offer. We're going to have a fixed rate of interest, not an initial rate, so we know it's a fixed rate of interest. Given where the interest rates are these days, we want to make an offer that the seller is going to say, okay, there's a good chance of getting this financing, so the seller's not wasting their time. So these days we're seeing interest rates anywhere from 6.5% to 8%. So we're going to come in and make our offer and say we want interest rate less than 7%. So that's going to be what the buyer is going to say. Amortization is the period of time that the loan is going to be amortized over. So if you think about a 30-year mortgage, that's pretty typical. And you'll notice I'm filling in all the blanks. We don't like to leave blanks in the contract. The next blank here is how long does the buyer have to make their financing application? We're going to give them the typical 5 days. And then if the buyer fails to waive the finance contingency after so many days, the seller or buyer can terminate. So how long do we want to give the buyer to get this loan application approved? I'm going to say we're going to give them 30 days. So let's go out to September 5th. That's actually 31 days. That's okay. And remember, at the end of this period, on September 6th, the buyer and seller can both terminate the contract, provided the buyer follows the instructions in the contract for providing the required information. Okay, the next up, we're going to figure out if the property is in a CDD or special taxing district. How do we know that? We have to go back to the property appraiser card that we're going to leave open. This time we're going to pull up the tax bill. This is all public information. We got our tax bill. We're going to look at the tax bill. Where would we find CDD information? It would be right here under the non-ad valorem assessments. On this property, there are no non-ad valorem assessments, so there are no CDDs. And we're going to say is not located in a community development district or MSTU. Now, next up, this is a very important section. Section 6 is about association and governmentally imposed liens and special assessments. How do we know if there are any special assessments on this property related to the government? Again, we go back to the tax bill. We look right here under non-ad valorem assessments. It says no non-ad valorem assessments. So there are no governmentally imposed ad valorem assessments on this property. Also, we looked at the property card. We're in Lake Park right here in the legal description. So we need to know if Lake Park is a association or not, a mandatory association or not. I can tell you that it is not. It is just a neighborhood in the city of Naples. So again, there is not going to be any association special assessments, and there's not any governmentally imposed special assessments. If there were, we would need to decide what happens to the special assessment after the effective date of the property. NABOR looks to the effective date of the property to determine when special assessments are going to be assessed. Everything due after the effective date could either be on the seller or the buyer. We're going to say in this case it's going to be on the buyer in case the city imposed an assessment during the next 40, 45, or 47 days for closing. Next, in section 7, we're going to look and see if there are any leases on the property. We have to ask our seller, does this property have any current or future leases? This property does not have any leases, so we're not going to check the box here on line 100. If it was, you check the box, and then you would have 5 days to review the leases, the buyer would. Up next, section 8, we need to determine if we're going to conduct inspections. So it's very, very good to conduct inspections on the property. So we're going to check box A for inspections, which means the buyer reserves the right to conduct inspections provided in standard D2A and the remedies provided in standard D2B. If you did not want to do any inspections at all, you said this is the perfect property, I know it is, you could check the box here for a waiver on line 107, and then there would be no inspections and the property would convey as is, as of the effective date. And we don't want to do that. We want inspections. So we'll check box A on line 106. Now, NABOR does not give you a lot of other choices in the contract. You go through the standards, you get to standard D here. Next, the next box is on line 243 for the number of days that we want to conduct the inspections. Typically, we do a 15-day or a 10-day inspection period. That's what we're going to do here. 15 days for inspections. That corresponds to our 16 days to get the second deposit in. That way the buyer can feel comfortable they've at least completed their inspections before the deposit's due. Remember, NABOR, it's 15 days for inspections, followed by 5 days for review of reports. Then the seller gets 10 days from when they receive the reports to make a decision. All that is in this part, but none of that is anything that you can change. The NABOR contract does not have any blanks or anything. They have the standard terms. until you get down to the bottom of the contract where you have other terms and conditions. Now, remember I said that this is a buyer, the buyer is a trust, and the buyer, I'll go back to the top here, the buyer is a trust, and you'll notice it doesn't all fit, the name of everything on here doesn't all fit under buyer's blank. So on the NABOR contract, which does not provide a lot of room for names, I go down to the bottom and I put a little asterisk and I say the full name of the buyer is Bob Buyer, trustee of the Bob Buyer Family Trust, dated 8/1/2020, 2000, sorry. Now, if I had other terms and conditions that I was going to put in here, I would not write them in without talking to an attorney first. But once I spoke to an attorney or got an attorney review, I could put any other terms in here. What you would not want to put in here is things like your commissions, things like sold turnkey. I think the best practices is to use the addendum. So today we're going to talk about the concession addendum, the inventory addendum. Where is inventory? Personal property inventory. And we're going to talk about how to use those addendums properly. The other addendums that we might look at today include the backup contract and the sale of, where is it? Buyer's existing property. There it is. So those are the addendum that we're going to look at today because I'm seeing a lot of those lately. Notice how I check the boxes here. There is case law. If you do not check the box, you have not attached the addendum to the contract and it's not valid. So now, before we get into all the addendum, let's finish our contract. Notice here that the signature blocks have been filled in for you by Form Simplicity. We need to put our brokerage information in here. So the listing brokerage is going to be me. Listing like the buyer's brokerage, we'll call it ABC Brokers. Listing licensee, put your name in here. Put the buyer's broker in here. Put your escrow information in here. Now the rule in Florida is that you have to fill in your escrow information. Oops. If I could type today. You have to fill in your escrow information. You should not leave this blank or put TBD. There is a Florida administrative code that says that you need to put all of this information in. So you need to get it from your favorite closing agent. That would be Sam Saad. And then you put all the information you see here. I can spell my information correctly. All right, so that's the contract. Then we click save. So now our contract is filled out, but we need to fill out our addenda and our disclosures. So going back to Form Simplicity. Now, the next addendum I want to talk about is the compensation and concessions addendum. NABOR provides this addendum, which does not auto-populate. Okay, now you have to decide, are you going to be asking for a credit towards closing costs and prepaids? Are you going to be asking towards credit towards broker compensation or some other compensation credit that the buyer is going to be receiving at closing. So you pick your choice. You can pick 1, 2, or 3. They can be done simultaneously. You do not have to pick just one or the other. Put your amount that you're going to want as a credit or your percentage as a credit here. I'm not going to put amounts in here because I don't want us to get in trouble for price fixing. I will tell you that as far as closing costs and prepaids are concerned, you need to talk to your lender because there's going to be limits. Fannie Mae and Freddie Mac go from like 2 to 9%, depending on the loan product that's going to be applied for. If you choose compensation as a credit here, then you would put your amount in whatever it is, your portion of the credit that the buyer is going to get a credit for. What I will tell you is don't write into the other terms and conditions, buyers or seller shall pay buyer's broker such and such amount. Use this a concessions form. It's a very simple form, has the language for you already in it, makes it clear. If you write it in, then you run the risk of writing something that is not clear, and then you may not get paid. So fill out your concession addendum, save and close. Next up, let's talk about the inventory. So the NABOR form provides an inventory form, of personal property, gives the buyer and seller 5 days to come up with an inventory, and then the buyer has 2 days to review the inventory and determine if they want to move forward. So you've got to go into the property, fill out the inventory form, which I'm going to show you now. Where is the inventory of personal property? NABOR provides this form. Come on up. And it shows the inventory. You fill this in, whatever you're going to be selling, in the foyer, the dining room, the living room, the family room, all the various places in the home, the bedrooms. Fill this in properly. I know it's difficult, and not a lot of people like to do this, but it really makes the transactions much more smooth. And then we attach this inventory to the bill of sale, and you get a clean transaction. And notice here the room for exclusions here, and then everybody signs, dates, and you've got yourself an inventory. Next, I want to talk about the sale of buyer's existing property. See this a lot these days. Buyers need to put their property in. So they put in the address of the property they're selling, which I think we said 123 Happy Street, Naples, Florida. And if the disbursement of this property does not occur on or before, pick a date sometime in the middle of your transaction, as soon as possible if you're the seller, as late as possible if you're the buyer. We're going to give them till the end of the month to get this closed. If the buyer does not close before August 29th or after August 29th, then the parties can terminate the contract. Save and close that. Now, the next thing I want to talk about is the flood insurance disclosure. This form is required for every single piece of property that you sell. Notice it has 3 questions now because it is new. This is the 2-question one. October 1st of 2025, it will have 3 questions. So we will do a class on that when it comes out. But for now, you need to determine the seller has or has not filed a claim with an insurance provider related to flood damage, which we have not. The seller has or has not received FEMA federal assistance for flood damage, which we have not. Then the buyer and seller sign, and this form is ready to go. Save and close that. Now, I am a broker, so we're going to talk about real fast about the licensee interest. This is a disclosure of licensee interest relating to the property being sold. So we put me in here. Sam J. Saad III is acting as the seller. So we fill that in there. And then everybody signs, and this form is good to go. So the last two forms that we need to worry about for our regular NABOR single family home transaction is the equal opportunity and housing brochure. So you would just submit this along with the contract. Make sure your buyer gets a copy of this. Nothing special there. It's 2 pages. And our energy efficiency brochure. So you send this along to your buyer as well. This one is 2 pages. Notice on this transaction that I am not using the lead-based paint disclosure. Why am I not using the lead-based paint disclosure? If I go back to my property card and I look at my property card, I see this house was built originally in 1973. But what happens if I dig a little? I look at the permits and I see that this house was actually rebuilt in 2004, right here. So I know that I do not need a lead-based paint disclosure. So that's something to look for. If the house is older than 1977, then you need 1978 or after. You do not need December of 77 or before. You do need lead-based paint. So we looked here, we saw that this is an old structure, but it's been torn down. We don't need that. So with that, that is the forms. Can I take questions, please? Any questions you have on the contracts?
I have a question about the flood insurance disclosure. What if someone had a flood issue that wasn't like on their flood insurance, but went through their regular insurance?
You would fill it out for any flood damage to the property on the first question. If you did not get federal insurance claim, then you would put no on the second question, but you would still have to disclose on the first question that you had flood damage. And I'll tell you this, when the new form comes out, it's going to ask an even more substantial question about ever getting flood damage on the property. And that's going to be difficult for people to fill out. But we'll get to that when we get there.
Is there like a saturation of baseboard flood damage because it was from water protrusion? Best to disclose?
The disclosure defines flood as the overflow of inland or tidal waters, the unusual or rapid accumulation of runoff or surface water from any established water source, or a sustained period of standing water resulting from rainfall. So that's what you need to know in terms of whether it's flooding. So if a pipe broke, then that would be different. Although the way the question is worded, where it says seller has or has not filed a claim with an insurance provider related to flood damage, including the flood insurance, the FEMA claims, I would be very careful about that. If I did have any flood damage in the property, I would check that I had flood damage on the new form. On the old form, if you didn't file a claim, then you wouldn't need to open that up.
Okay, thank you.
Yep. Other questions?
Hey, Sam,
yes.
you went over the concessions form.
Yes.
Can you explain the difference between the concession form, using that for compensation, and the broker compensation agreement form?
So,
which is also
and
used?
I could spend all day on that, Mike, but let me just say simply, when we're talking about filling out the sales contract, the broker compensation forms, the buyer's broker forms, the listing forms, all those forms are other contracts, and they are not part of the sales contract. Now, this gets very confusing for people because you saw where I filled in the concession form and I said what the compensation was that the buyer was receiving a credit for. So the seller is providing a credit to the buyer's or the buyer's broker for compensation on the forms that I went over. If you though the other forms, the buyer broker agreement between the brokers, or I'm sorry, the buyer broker agreement between the buyer and the buyer's broker, or the agreement between the seller's broker and the buyer's broker for compensation, those do not actually attach to the sales contract. That's a misnomer that a lot of people will do. They'll say, no, I'll attach my broker to broker compensation agreement to the sales contract. That's actually between the brokers who are not parties to the sales contract. Does that make sense?
It does.
So a lot of people will want to attach their buyer broker agreement. They want to attach the listing agreement. They want to attach the broker to broker or the seller to buyer's broker. None of those forms actually are supposed to attach to the contract. The contract is the deal between the buyer and the seller for the property, and the reference to compensation should be on the concession addendum. Now, what happens is people get worried. They say, I don't have an agreement for compensation if I'm the buyer and I want to make this offer. There's a different addendum called the compensation addendum. And that addendum is where you make a contingency so that the buyer broker and seller's broker can negotiate the compensation afterwards, after the contract is signed. And that's usually 3 days is the standard in that form.
Okay.
Does that make sense?
Thank you. Yeah, thank you.
Other questions? Nobody's got any questions? Well, I'm trying to keep these to a half an hour. We're at 35 minutes. So I'm going to say thank you to everybody for your time this morning, and hope to see you on Thursday for the next one. We'll be talking about FARBAR. And then after that, we'll get into all the different little parts of the contract. So thank everybody today, and I'll talk to you all soon.